John Wick is very simply a movie about a man who goes on a killing rampage after his dog dies. That doesn't have a whole heck of a lot to do with estate planning. We don't do plan estates for pets. But what if the situation was reversed and John Wick died and then his pet survived after him? Maybe going on a killing rampage, I don't know. But in that case, John Wick would have needed to make sure that his estate plan, his legacy plan, was taken care of so that his pet would have somewhere to go. My name's Gregory Singleton. I'm an estate planning attorney with Signature Law, and we're here to talk estate planning. And today's video is part 2 of 2 about estate planning involving pets. And specifically, we're going to talk legacy planning. How can you make your plan so that after you pass, your pet is taken care of? Just as a reminder, there are essentially 2 times that we care about in estate planning, which is when you're alive and incapacitated and after you've deceased. Today we're going to look at after you've deceased, which is called post-mortem planning or legacy planning or what have you. You of course need to do planning in both. If you're worried about incapacity planning, which is planning while you're alive and incapacitated, check out the previous video. And today we're going to look at 2 specific strategies to use for planning for your pet. And the first one being the Cadillac of legacy planning for pets, which is the pet trust. Now, very simply, a pet trust is where you create a pet or trust for your pet, where the pet is the beneficiary. Now, the pet doesn't actually go in the trust as an asset, though technically it could, but that's not what we're doing here. Now, in 2016, Minnesota became the 50th state to pass a statute authorizing a pet trust. And why was that important? Well, to have a trust, you have to have a beneficiary. And just part of the definition of the trust. And a thing cannot be a beneficiary. This pen cannot be the beneficiary of a trust. Pets are tangible property under the law. So in order to authorize having a pet be a beneficiary, have a thing be the beneficiary, we had to pass a statute. And we passed Minnesota Statutes 501c.0408 in 2016, authorizing the pet trust. So what are they? You leave a lot of money for your pet. In the trust, you have various instructions on what that money can be used for to pay for on behalf of the pet. Care, medications, training, environment, that sort of thing. Generally, pet trusts are for larger amounts of money. The reason for that is because it costs north of $1,000 or more to create a pet trust. So generally, we're talking people that want to leave like $50,000 to $250,000 to their pet, or even more. Leona Hemsley was a famous example of someone that had a pet trust, which was actually rejected by the courts. There is the Gunter Foundation for a German Shepherd named Gunter that was left millions of dollars many years ago. And the pet trust is still going on, by the way. You can't do that in Minnesota. But they're generally for larger amounts of money. Now, there's a few quirks with pet trusts that you should be aware of. I have a whole video on pet trusts, so we're just going to touch on some of the basics. One is I call the puppy limitation. If you leave a trust for Fluffy and Fluffy dies, Fluffy's puppies, which would be Furry and Harry and whatever else, they cannot become beneficiaries of the trust. When the first pet that is named, the pet that is named as a beneficiary in the trust dies, the trust disintegrates, is terminated, and the assets are distributed elsewhere. Second is kind of a unique one, is the Secure Act. As you may be aware, the Secure Act is a law that limits how long assets in a qualified retirement account can be kept in a trust. If you fund a trust, a pet trust with retirement assets, those assets will need to be distributed before 10 years is up, or possibly 5 years is up. There is no exception for pets under the Secure Act. Generally, again, pet trusts are for high maintenance pets, either ones that have a lavish lifestyle or whose regular lifestyles are expensive, such as horses, and they're not for everyone. So let's bring it back down to earth a little bit and talk about what is the most common strategy for addressing pets after you pass. And it's very simply putting in a provision in your will or your revocable living trust. A few things about this. First of all, you don't necessarily need or want to name a specific pet in the trust. The provision will read something along the lines of, I leave any pets that I have at the time of my death to Bob, if he's willing or and able to take care of the pets. And if Bob can't do it, then Sue, etc., etc., etc. Have some successors. That's the big first one. If you name Fluffy as your pet, and then Fluffy dies and you'd adopt another dog named Bruce, but you haven't updated your will or your trust, all of a sudden the pet clause that you have is going to lapse. So if you're going to name your specific pet, and there's some reasons to do it, if you're going to name your specific pet, make sure to include a catch-all, such as I leave Fluffy and any other pets I own at the time of my death. One reason you might want to name a specific pet is if you need to split up your pets, or you can even make a class of pets. So I give Fluffy, my dog, to Sue, and I give Bruce the cat over to Bill to take care of, and any other pets that I have. Again, having successors is important, more important in many ways than other fiduciaries. And the reason for that, take for example, a guardianship of minor children. If I am going to name my brother Bob as the primary nominee for guardian of my children, my brother Bob is probably going to go out of his way if I prematurely die and he's got to take care of the minor kids. He may move. He may make whatever adjustments in his life he has to do to take care of those kids. People tend not to do that for pets. And if you've named a guardian, say, that moves into an apartment that doesn't allow dogs or cats or fish, all of a sudden, it's very unlikely that that guardian you named is going to move their apartment just to take care of that pet. So make sure you have some successors in place. Also, you can make a list of places that the pet can go, no-kill shelters or other places that may act as a placement agency for your pet. Another thing about these pet provisions and wills and trusts is you might want to compensate the trustee, compensate the person who's going to be caring for the pet. Give them $1,000, give them $5,000, whatever it may be. One thing to think about is using a calculation. Say you have got a pet. You estimate the average number of years that a pet will live, their average lifespan, and say $1,000 a year. They'll use less of it at the beginning, but more of it at the end, towards medical care for the pet comes up. You could, of course, make a mini trust, not a pet trust, but a compensation trust for the caregiver. Say, put $10,000 into a sub trust or a nested trust or testamentary trust within your will or trust, or revocable trust, and then the money pays out of that trust over time to the caregiver of the pet, who is the beneficiary. The caregiver is a beneficiary, and another trustee needs to actually be the trustee of that pet. Realistically, it's easy to overcomplicate and overthink these things. Keep it simple, and keep it as straightforward as possible. Now, I think I said we had two mechanisms earlier. There's a third that I want to talk about that I forgot about. That is the tangible personal property list. Now, a tangible personal property list is very simply a provision in your will that sets up, that authorizes you, or will or your trust, that authorizes you to write a letter and say, I leave this item, this pen, to Bob down the street. You sign a date at the bottom of it. You don't need witnesses, notaries, lawyers, or anything. It's legally effective. And then the very next day, you could be like, I gave this pen to Bob, but Bob gave me the stink eye. I'm going to leave it to Susan. You rip up the old letter, sign a date, a new letter, leaving the pen to Susan. She gets it. Now, you can do this for any tangible personal property. So that excludes real property, of course, or real estate. It excludes money, coin collections, intangibles such as stocks and bonds. It's also going to exclude business assets. But anything else you can leave in a tangible personal property list, including pets, because under the law, pets are tangible property. So if you have, before you get it around, if you've used a pet provision in your will and you said, I leave my dog Fluffy to Bill, and you adopt a cat named Bruce, in your tangible personal property list, you can just say, I leave Bruce to Susan. Again, with all of these, make sure you leave instructions for your pets about what their needs are, what their medical needs are, and what they're used to and accustomed to. It'll make the whole transition a lot easier. It is very, very, very important to notify the person who's planning on receiving your pet. Last video, we talked about having a card in your wallet that notifies in case of emergency contacts, who to contact, and those contacts are healthcare agents, and those healthcare agents know to contact the pet guardian or custodian to take care of your pet. Make sure to have that in place so that if you go to the hospital and you die, then your pets are taken care of. The last thing I want to talk about briefly is why this planning is so important is because of family discord. On one hand, there always is a situation where two people want the same pet. That happens as with any other asset. But the issue that I would like to talk about is when nobody wants the pet. And I see this quite a bit. There will be an elderly person who hasn't done their proper planning, and their son apparently feels the obligation to take on the dog. And they don't feel it's okay to give up the dog to a no-kill shelter or something like that. They just are stuck with this pet. And you don't want anyone feeling like they're stuck with it. And pets are slightly different because we don't, hopefully, just dispose of them. Like if I'm given a painting and I think it's a big painting of a purple clown and I can't stand purple clowns, I can just get rid of the painting. But pets you can't really do that with. So be careful, make sure you plan ahead and talk to somebody about who's going to be receiving your pets. And that's all I've got to talk about today. This is my take on legacy planning for pets. I hope you liked today's video. If you did like today's video, please feel free to like and subscribe. It actually really helps support the channel. If you have questions, leave them in the comments below or send me an email. Love to see that. Otherwise, until next time, this is Gregory Singleton with Signature Law.